9 a.m. docket.
Thank you, Mr. Shima. I'll ask counsel in 127544 Powerback Rehabilitation LLC versus Kansas Department of Labor to please come forward.
Hey, please the court. I'm Deputy Solicitor General Dwight Carswell, appearing on behalf of the Kansas Department of Labor. I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. The requirement in KSA 44-663 that employers grant religious exemptions from COVID vaccine mandates was not preempted by the CMS vaccine mandate, nor does it violate due process. The district court erred in concluding otherwise and should therefore be reversed. The CMS vaccine mandate itself recognizes that there's a religious exemption under Title VII. Now, Powerback points out that Title VII allows employers to inquire into the sincerity of religious requests.
Does it allow, or does it? It seems like it's stronger than just allows. Doesn't it? If a religious exemption is exercised, doesn't it require?
Just the opposite. In fact, it discourages employers. The EEOC guidelines say that ordinarily an employer should assume that an employee's religious exemption is sincere. There are limited situations where, yes, under Title VII, an employer can inquire into that, but ordinarily an employer should presume that it's not, and it never requires an employer to. An employer can comply with Title VII by presuming across the board. And so that's why there is no conflict between Title VII and the CMS vaccine mandate and its Title VII exemption and state law, because each and every exemption under the Kansas statute could also be fully justified under Title VII.
Let me ask you this. I'm looking right now at the EEOC guidance on COVID and EEO laws, which was cited by the IFR. And in fact, there's also a template. But based on what you've said, it said, yes, it says generally under Title VII, an employer should proceed on the assumption that a request is based on a sincerely held religious belief, practice, or observance. However, if an employer has an objective basis for questioning either the religious nature or the sincerity, the employer would be justified in making a limited factual inquiry and seeking additional supporting information. So, although, I mean, I get what you're saying, that it's not a requirement, that it is permissive, I guess you would say, just like the assumption is permissive, right? They're both permissive. But the guidance does say that you can, if you have an objective basis for questioning. And what I understand you to be saying is that that the state law, which prohibits this, is not in conflict with the EEOC guidelines, which does allow it.
Well,
Not really getting that.
Well, the EEOC guidance and Title VII more generally, which is what we're really talking about, allows an employer to inquire. It's, as you say, would be justified was the language there, but the employer does not have to. And so the employer has the option to. And so any exemption under the Kansas statute could also be granted under Title VII. And so there's no conflict because an employer complying with the Kansas statute would not be violating Title VII. If they grant an exemption under the Kansas statute, they wouldn't be violating Title VII. They'd be complying with it.
And when you're looking at the CMS vaccine mandate, and I don't know, do we would just want to call it the vaccine, the rule, whatever we're calling it. You know, I mean, I just now commented about it, you know, preemption as a conflict, but why isn't it an express preemption? Because it says right here that request for exemptions must be documented and evaluated. As is relevant here, this IFC preempts the applicability of any state or local law providing for exemptions to the extent such law provides broader exemptions. Why is that not an express preemption?
Well, 3 points. First of all, in Wyeth v. Levine, the Supreme Court said we don't defer to agency pronouncements of preemption. We actually look, the court entertains an independent inquiry into whether there's a conflict. Secondly, what you said. Okay.
That's a conflict. I'm talking about express.
Well, I mean, what the Supreme Court is saying is we don't defer to what a agency is saying about, we think this is preempted, which is what you're referring
What
to
about
there.
City of New York versus FCC saying valid agency regulations constitute federal law for preemptive purposes?
They do, and you have to actually look as to whether there is preemption, not just what the agency says about whether there's preemption.
In such a case, the correct focus is on the federal agency that seeks to displace state law and on the proper bounds of its lawful authority to undertake such action. Do you believe that CMS had that lawful authority?
They had the Supreme Court upheld, yes, their authority to do the CMS vaccine mandate.
In
Or-
the Biden case?
Exactly.
Right.
The second point is, you said broader, the regulation goes on, it's broader and inconsistent. So CMS itself is saying it's only to the extent there's a state law that's inconsistent. We also don't think it's broader, by the way, but
So you think you have to show both?
that's what
Do
it
you have
says.
any case law or any?
Well, I'm referring to the language of the regulation. It says broader and inconsistent. That's the and is requiring both. And we also don't think it's broader in at least one sense, in that the outer bounds of the exemption is the same in that, like I said already, the exemption under the Kansas statute could also be fully justified under Title VII. So Title VII is not somehow narrower. This doesn't exceed the bounds of Title VII. It would be fully
But
within the
it
scope.
constricts. I mean, it's basically saying it makes null and void, doesn't it? The permissive part of Title VII that allows you to inquire?
Well, it doesn't exceed what Title VII allows an employer to grant. An employer would
Right,
still
but
be
it
within the scope.
substantially limits. So, I mean, when you look at what the purpose of this was, is, vaccinations in environments where people are very susceptible to getting COVID and dying. And then someone says, I mean, it makes it so it defeats the whole purpose of the CMS, of the IRL or IR something.
I don't think so. I mean, I think it's consistent with Title VII, which allows religious exemptions. I mean, just to some extent, granting
And-
religious exemptions is a conflict with requiring mandatory vaccination, but that's a balance that has been made. And then the question is just, well, how do you analyze religious exemptions? Our third point, just briefly, is that language you referenced is in the preamble to the regulation. That's not actually the regulatory language that's enacted.
And what law is there that says, I mean, to me, I read this and the preamble, which by the way spans 29 pages. The preamble says, okay, here's the reason why we're doing this rule. Okay, here's the reason why we're doing this rule. And now here's the rule. Why would the preamble not count as an agency action?
I mean, it is an agency action, but it's not the binding law.
Why not?
I mean, that's what precedent.
Okay, can you give me that precedent? Because I couldn't
Sure.
find it.
I mean, we cited it in our brief. I'm not sure if I wrote it down here, but it's in our brief. There's 10th Circuit case and I think DC Circuit case we cited that said what's actually binding law is what's enacted in the CFR, not the agency preamble.
So but this was published in the CFR, or was this just in the Federal Register?
So the whole rule is in the Federal Register.
Right.
Then the second part of it is in the CFR. So it's only what's in the CFR that's actually binding. The rest is explanatory material.
What is the site for that, or for the CFR? Do you have it?
The CFR,
Site.
there's a bunch of different, because CMS regulates a whole bunch of different entities, so it's all over the place, but it's at the end of the Code of Federal Regulation. I mean, the Federal Register. So it's in the rule itself.
Right. I found the Federal Register sites and all that. I couldn't find the CFR site.
Well, they're within at the end of the rule itself. It talks about this Code of Federal Regulations is hereby amended at these various sections, and they're ambulatory surgical centers and then various various
I'm
entities.
sorry for taking.
No problem.
In your discussion about the regulatory and what we look to for the regulatory language in preemption area, do you have, or is there a case law evolving about what the recent U.S. Supreme Court's dealing with the Chevron doctrine, how that might impact any of the view of how we look at this from a preemption standpoint?
I'm not.
In terms of giving really just overall less deference to regulatory statements. Is there anything yet that's come out that really gives us a clue of whether that will impact how we look at this from a preemption standpoint?
I'm not aware of anything, but I mean, the district court didn't rely on Chevron, and I don't think, obviously, there would be no deference to the agency. And in fact, in the Wyeth v. Levine case, the Supreme Court said we conduct our own conflict analysis. We don't defer to agency pronouncements. So I don't think that really changes anything. We're arguing you don't give deference to the agency. You actually look at whether there's a conflict, and we don't think there is a conflict here. I'd also note that.
And if I understand correctly, the district court found the source or the origin of the conflict to be in Title VII, essentially with the state statute.
I think that's correct.
Yeah. And so what is that? What is the really overarching purpose of Title VII? Isn't it to protect employees from non-discrimination?
I think that's fair.
And the state statute seems to, if anything, provide that very purpose, right? By providing the same religious exemption and maybe limiting inquiry into that.
Yes, the state statute is also designed to protect employees' religious beliefs.
Okay. And then do you agree that the state statute still leaves room for an employer to deny an exemption because the employer believes it's not sincerely held, just based on the content of the written statement that the employee submits, without further inquiry beyond that, but just on the face of the document that the employee submits in support of the exemption?
No, I don't think an employer can say your views are not sincerely held. There may be room to say it's not religious, but it's not sincerely held.
Why couldn't you
Well,
say
yeah.
that if the employee, I mean, this would be silly, but what if they just said, I'm not religious, but I'm claiming a religious exemption?
Well,
They said that.
under the statute, they have to say it's religious. The statute says they have to submit a written waiver request stating that complying with such requirement would violate sincerely held religious beliefs of the employee.
Right. So
They have to.
if they just don't do that,
Well, then the
then
statute's not.
the request can be denied.
Yes, absolutely. If they don't satisfy the initial, but what I'm saying is if they comply with that, the employer can't say, you said this is sincere, but based on what you said, I don't think it actually is.
Right. The submission itself has to show a sincerely held belief,
They have
or
to-
at least declare it.
They have to declare it, and then they have to, it says is evidenced by an accompanied written statement. It doesn't say what that is, but they have to provide something minimal, I think, but yes. I'd also note that the fact that there is no conflict, there's just no likelihood that if Powerback had granted this exemption, that they would have lost their federal funding as they suggest. The mandate itself says that CMS established minimal compliance burdens for this. See that Powerback has presented no evidence that CMS was going around probing into the sincerity of the religious beliefs of individuals who had been granted exemptions. In fact, the CMS said just the opposite in statements to the media. In Kansas, Governor Kelly, in Executive Directive 22-550, ordered state CMS-funded facilities to comply with KSA 44-663, and the federal government didn't come in and cut off state funding. So the whole idea that Powerback would have lost its federal funding if it had granted Ms. Kieran a religious exemption is just unfounded.
What if someone would have died? Do you think there was any liability there? What if
They had granted.
if 10 patients would have died because they worked with this woman who think she was a occupational therapist during this heightened that's when this big spikes came up. What if 10 patients would have died? Would Powerback would have been subjected to liability for lawsuits?
I would think if they granted a religious exemption as required by the statute, that would probably have been a defense in a tort lawsuit. I don't know for sure, but I'm sure they would have argued that.
Just spell it out for me. I'm having trouble here, and I guess it's kind of where I started. If something allows something and what it allows is prohibited on the other end, why isn't that in conflict? I don't understand how that isn't. You're basically saying it's the same, and I don't see where it's the same. How is it not in conflict?
I'm not saying it's the same. I'm saying it's not a conflict. So put aside the CMS.
Yeah, how is it not a conflict? I mean, something that prohibits something is pretty blanket and pretty broad. Something then that allows that very prohibition isn't the same. It's narrower.
So
So why isn't this a conflict
put aside the CMS
under
vaccine
the
mandate.
preemption? kind of analysis.
Just under conflict preemption generally, I mean, it's frequently the case that state statutes go further than federal law. I mean, it's federal law may not require, something, and the state statute may, well, we prohibit this form of discrimination even though it's not prohibited under federal law. That doesn't mean the state statute's prohibited or in conflict with federal law. It just goes further than that. There's only a conflict if you can't comply with both. And here you can comply with both because you can grant any religious exemption under the state statute could also be justified under Title VII. So it's not impossible to comply with both.
Is that the test? If you can comply with both, then it's not a conflict?
That is at least one preemption test. There's also express preemption and obstacle preemption and whatnot.
Before you sit down, I wanted to ask you to at least briefly articulate your claim that if we find preemption, we should find that the federal regulation is unconstitutional.
It's not that it's unconstitutional per se, it's that Powerback had an obligation to turn down the funding. The regulation would still be constitutional. It's just if the acceptance of conditions on federal spending would violate state law because it's a spending clause regulation. The only reason it's binding on a party is because they voluntarily accept the funding. That's not something that they're required to accept, even though obviously I understand their financial pressures to do that. It's their choice to accept.
You're arguing it's a spending clause violation.
It's
right?
a spending clause violation per se. It's that.
Well, it's that Congress does not have the authority to attach this particular string to these dollars.
Congress can attach the string. It's that Powerback cannot rely on accepting that to violate state law. It has to comply with state law and turn down the money. Because the only way Congress can impose that
even if it's preempted.
I'm sorry.
Even if it's preempted.
Well,
I don't understand. I guess, okay. I didn't expect that to be your answer. Help me understand why you're making that argument.
Sure. So under the whole idea behind the spending clause is that Congress can't force a party to do something. The only reason it imposes that is because the party in exchange enters into a voluntary exchange. We accept the money in exchange for agreeing to these conditions, but that's completely voluntary. A party can't be forced to do that. So if one of the conditions would violate state law, a party going into that bargain just has to say, no, I'm sorry, I can't enter to that contract.
If state law is preempted, it doesn't matter, right?
Well, state law is not preempted.
Well, I thought this was your backup argument.
It is the backup argument.
But if it's preempted, it doesn't. Maybe we're just talking past each other.
Well, I mean, it's not if it's preempted, I suppose. Maybe that's where it's wrong. If there's a conflict, I should say. If there's a conflict, then Powerback needs to turn down the money.
Okay.
They would need to opt out of Medicare and Medicaid altogether?
I know that there are obviously financial pressures, but yes, they can't.
Well, and public policy.
I'm sorry?
And public policy repercussions from that. And I mean, is that what hasn't the Bartlett decision, like the United States Supreme Court suggested that they shouldn't be, program participants shouldn't be forced into that all or nothing sort of choice.
Except the whole idea behind the spending clause is that you can't force someone to enter into a bargain. It has to be voluntary. So.
Right. So that's what I thought was your argument, was that this exceeds Congress's authority because it's an unlawful coercion through the spending power. I
mean, if they're saying we had to accept this, then yes, I think at that point it would be, but that hasn't been their argument. Okay. So far. It's been, we have to do this because we accepted this money. But that was their choice, and they could comply with both state and federal law by simply turning down the money.
So am I understanding the argument then is that if there is a conflict, the party has an obligation to cure it rather than to rely on preemption?
I mean, the point is that if there's a conflict, they're under no legal obligation to accept federal funding.
But what if they want to? Why doesn't preemption still apply?
You can't just choose to violate state law unless there's some federal law that forces you to.
Well, why can't you choose to violate it if your position is that the state law is preempted and then you win in court?
Well, the only reason it would be preempted, though, is if there's binding federal law that conflicts with it. And the point is there's not binding federal law because it's not binding.
So you're just, in the end, you're just circling back to it's not preempted.
There's no condition under which it's preempted, yes. There may be, we don't think there's a conflict at all, but to the extent there's a conflict, it's not preempted yet. Yes. Unless there are further questions, I ask you to reverse the district court. Thank you.
Thank you. Drew?
May it please the court, Melody Rail on behalf of Appellee Powerback Rehabilitation LLC. Good morning. We would argue that the district court properly found that KSA 44-663, which I'll refer to as the Vaccine Act, is unconstitutional as applied and on its face for three primary reasons. I'm going to focus my argument on these three reasons. First, the Vaccine Act is preempted expressly by the IFR because the Vaccine Act provides broader protections than federal law with respect to the accommodation of bona fide, sincerely held religious beliefs. Second, to the extent that there is not an express preemption, the Vaccine Act is nonetheless nullified under the Supremacy Clause because it conflicts with or frustrates the purpose of the IFR. And finally, the Vaccine Act violated the procedural and/or substantive due process rights of Powerback in that it deprived them of property rights for arbitrary reasons and without a meaningful opportunity to be heard. I'm not going to belabor the facts in this case, but I want to point out just a brief chronology. On August 2nd, 2021, in the wake of the resurgence of the Delta variant of COVID-19, Powerback implemented their vaccination policy, mandating that their healthcare workers, who, by the way, all work in facilities that are populated by the most vulnerable citizens of the state of Kansas, the elderly and the infirm. On November 5th, 2021, the U.S. Secretary of Health and Human Services promulgated the IFR, mandating that in order to receive Medicare and Medicaid funding, participating facilities should make sure their staff is vaccinated. On November 23rd, 2021, the Kansas legislature, in direct response to the IFR, passed the Vaccine Act, declaring, if you will, narrower circumstances under which vaccine exemptions had to be granted. And I want to focus the court on the express argument because we believe that that resolves the issue. Under the Supremacy Clause, state laws that interfere with or are contrary to the laws of Congress are invalid.
Can I just interrupt real quick and ask kind of a big picture question?
Yes, Your Honor.
Is your argument that if a state grants broader protections against discrimination than the federal government, those broader protections are preempted?
If, Your Honor, I was arguing that this is conflict preemption, which I may argue here in a moment, that would precisely be the argument. But I want to first address that it's expressly preempted.
And I appreciate that, and I don't want to get you off track from that argument. But just really quickly on the conflict portion, can that really be right? I mean, if the federal government does not prohibit discrimination against a certain class of people, whoever they might be, and then a state decides to say, no, we don't want you to discriminate against those people, how could that be preempted?
Under the circumstances here, the conflict arises because employers are required under Title VII to engage in an interactive process to determine whether or not there is a sincerely held religious belief, and then to select an appropriate accommodation. And under the statute, the Vaccine Act, the menu, if you will, of potential reasonable accommodations is one thing. They have to be given their job. They have to be given an exemption. The employer can't even consider, well, okay, if you have a religious objection and it's a bona fide, sincerely held religious objection, then we'll put you in a different spot where you're not dealing face to face with patients. You're not interacting with our vulnerable elderly citizens. But you can't do that under the Vaccine Act because the Vaccine Act expressly prohibited employers from doing that.
I appreciate that, and feel free to return to your argument about express preemption.
Thank you.
But before you do that, can I'm going to just tag on one question to that because it was just so immediate in your response that there's no liability for an employer to simply grant a religious exemption without doing an interactive process under Title VII, right?
Well, the liability wouldn't be for just granting the exemption. The liability would be for what the result of granting that exemption is.
But we're looking to Title VII as in terms of a conflict. And for the employer, just granting the exemption without any sort of, interactive process doesn't create liability under Title VII, does it?
It wouldn't create liability under Title VII, no, Your Honor. But Title VII affords certain benefits, if you will, to the employer for public policy reasons so that the employer can operate its business and in this case, protect its patients. And so it frustrates the purpose of, it conflicts with that notion, Your Honor.
Okay.
I keep thinking that nobody wants to just show me language in Title VII or anywhere else that says the employer must inquire as to the sincerity of the religiously held belief. I mean, I've looked all through, I've reread your brief twice. I did it last night for the second time, and I nowhere in here do you just cite me to the language that requires that. It's cobbled together by saying, oh, well, there's this purpose and that purpose. And when I look at it, the language about making an inquiry is about what accommodation has to occur because of the exemption, not an inquiry as to whether you get the exemption. And so I'm looking for, where does it say you're required to probe the sincerity of the employee's exercise of this exemption?
Yes, Your Honor, and I'll refer you to the EEOC's guidance, which the IFR directly incorporates into its language. And the EEOC's guidance, if you will, which is found on the EEOC's website, states as follows. However, if an employee requests a religious accommodation and an employer is aware of facts that provide an objective basis for questioning either the religious nature or the sincerity of a particular belief, practice, or observance, the employer would be justified in requesting additional supporting information.
But it doesn't say required to go do it. It just says if this is there, it'd be okay to ask for it. And all the state law says is, no, you don't do that. So again, I think we have to agree that nowhere on the federal side does it say an employer must make this inquiry into the sincerity of the belief.
Well, Your Honor, and I'm gonna try to dovetail back to my express argument here in a moment, but to answer your question, there's nowhere in Title VII where it says that part of the interactive process is determining whether or not an accommodation is needed at all. But the cases that have interpreted Title VII in all aspects of providing accommodations, whether it be for disabilities, for religious observances, or for whatever reason, initiates the interactive process at the moment there is an indication that an accommodation is needed. Here, that would be when someone says, I have a sincerely held religious belief. The inquiry begins there. And the cases have interpreted across the board, across the nation, that that's what Title VII requires. And that the first prong of that is to determine whether or not the trigger for the accommodation exists at all. Does the employee have a disability? Does the employee have a sincerely held religious belief? And so our argument would be that that inquiry into whether or not there's a sincerely held religious belief, if there is some reason to believe that there may not be, is absolutely required under the Title VII interactive process.
The way I'm interpreting what you're telling me, and so just correct me if I'm wrong, because I've struggled with this a lot, is it isn't in the federal law. It's not in the regulations. You've got to go look at some case law that imposes this obligation to probe the sincerity of the exercise of the exemption.
I would agree with that, Your Honor.
Okay.
You would have to look to how the courts have interpreted the requirements under Title VII.
Okay.
If I may, I want to go back to the express preemption argument.
I am so sorry to do this.
That's okay. Justice Standridge, go right ahead.
Okay, so I just want you to briefly respond to your colleagues saying that where it says, to the extent such law, this is express, provides broader grounds for exemptions than provided for by federal law and are inconsistent. He's saying that those are both required. And even if it is broader grounds, they're not inconsistent. So it kind of gets rid of the express altogether.
Your Honor, I would answer that in two ways. I would first say that my reading of the statute is that the and inconsistent is inherent in if it provides broader protections. In other words, if it provides broader protections, it is inconsistent. And it then follows that if there are broader protections, which there clearly are here, that it is therefore inconsistent with the IFR, certainly frustrates its purpose, which is one of the prongs of analysis that's used.
Okay. And then there was another argument he made about express. The other argument he made is, it doesn't count if it's in the preamble. And I couldn't find the case law that he cited in his brief. I mean, I don't remember the case law. Sure, it's in there somewhere. But how would you respond to that preamble doesn't count?
Yes, Your Honor. I think the preamble does count to the extent that it states the purpose of what the IFR stands for and certainly indicates the language of the express preemption. The preamble can't just be ignored. It's part and parcel of the IFR. And if it was part of what was published in the federal regulation, then certainly it's something that the courts look to in determining whether or not there's express preemption. I also noted that my esteemed colleague relied on a case by the name of Wyeth versus Levine, but the facts there are very different from the facts here. That involved whether a state could require more robust labeling on medications. And there was nothing in that case that indicated that the federal regulation intended to preempt any state laws. They just made the comment that the state laws should, sort of be consistent with this. And that's not what happened here. The language is very clear. And in fact, the Kansas Court of Appeals just recently held in January in St. Luke's Health System, and I will quote, "The definition of religion adopted by the federal courts is much more demanding than the definition of religious beliefs in the Vaccine Act." Essentially saying, yes, the Vaccine Act is broader in terms of how it defines religious beliefs. And the way in which it is broader is that under Title VII, the definition includes that social, political, or economic philosophies, as well as mere personal preferences, are not religious beliefs protected by Title VII. That definition is included nowhere in the Vaccine Act. I would also state that because the Vaccine Act states that an employer is prohibited from inquiring into the sincerity of the request, that is violative of the EEOC guidance that we've been talking about. And again, the Kansas Court of Appeals in St. Luke's Health System acknowledged, and I quote, "The first prong of a district court's inquiry into whether a plaintiff has plausibly pled a prima facie Title VII religious discrimination claims includes examining whether the employee's belief is sincerely held." The IFR contemplated this when they included the language in the regulation that says, first of all, we intend, consistent with the Supremacy Clause of the United States Constitution, that this nationwide regulation preempts inconsistent state and local laws as applied to Medicare and Medicaid certified providers. And it preempts the applicability of any state or local law providing for exemptions to the extent such law provides broader grounds for exemptions than provided for by federal law and are inconsistent with this IFC.
Can I ask, when, and it's on topic here with what you're talking about, but when, if we're operating under the federal regulation and there's a determination made that there needs to be an inquiry and I understand there's some guidelines for the inquiry. There's some suggestions. Who ultimately decides whether it's a valid request or not, or it's a valid, sincerely religiously held belief? Who makes that? The employer does, or who does that?
Yes, Your Honor, as a threshold matter, the employer makes that determination. Now, obviously, it could end up in the courts and the courts could decide that the employer got it wrong, but you're correct, the employer makes that determination. And the facts in this case are a perfect example of why that inquiry is allowed. Because when Powerback did make the inquiry of Ms. Kieran, her response was, well, heck, I don't know. I don't know enough about this vaccine, and that's why I don't want to get it. And so it demonstrated that it really wasn't her sincerely held religious belief at all. She just didn't trust the vaccine and didn't want to get it. Now, it was a violation of the statute for Powerback to even ask that question. But her response is a perfect example of why the employer should be permitted to make that inquiry. Because when they did so, it was found that maybe her objection was not religious at all. It's interesting, the Kansas legislature stated when they passed the Vaccine Act that the purpose behind the Vaccine Act was to protect the religious practices of the citizens of Kansas. But Title VII already does that. And my esteemed colleague, when he was giving his argument, he acknowledged that the protections afforded by the Vaccine Act, according to him anyway, are the same as provided under Title VII. So the very purpose for enacting the Vaccine Act were already accomplished by Title VII. And the other thing that I would point out in terms of how, and by the way, I see I'm out of time. Do you mind if I finish this thought?
You may continue.
Thank you, Chief Justice. The third way in which the Vaccine Act provides broader protections than the IFR or Title VII is under the undue hardship analysis. And the statute says that you can't provide any accommodation for an exemption that would be punitive in nature. And it gives some examples. You can't transfer somebody. You can't withhold certain duties from them. All of those things are things that can be done as a reasonable accommodation under Title VII. But here, the Vaccine Act removes that and eliminates the possibility of the employer's ability to say, this is an undue hardship for us to let Ms. Kieran interact with our vulnerable patients. Under the recent Supreme Court ruling in Groff versus DeJoy, it would absolutely be a reasonable accommodation for them to move her into a different position, but the Vaccine Act precluded that. With that, I'll entertain any additional questions.
I do have a couple questions about express preemption. And just thinking about express preemption 101, I guess. Would you agree that it's pretty clear that the Supreme Court has stated that there's a presumption against preemption? That we shouldn't, basically that, the idea is Congress doesn't typically want to interfere with historic state police powers. So we're going to start with this presumption against a preemption. Would you agree with that?
I would agree with that.
And then following up on that, and it kind of follows naturally, the Supreme Court has made it pretty clear that we won't find an express preemption absent a clear and manifest purpose of Congress.
I would agree with that as well.
Okay, so my question is, where in this case would you point us for us to find that clear and manifest purpose of Congress?
The clear and manifest purpose of the IFR was that, and it's
well,
unfortunate.
And I apologize, Bob, I'm going to interrupt you because I'm looking for something that would show us what congressional intent was, not necessarily the agency's intent. Isn't there a difference between those two?
Well, the agency is empowered by federal statute to enact rules and regulations.
So is there anything in the Enabling Act in Title VII or anywhere else that Congress passed that would suggest that Congress wanted the agency to have the power to expressly preempt this kind of state police power?
I'm not going to be able to point you to anything in Title VII that says that, Your Honor, but the whole purpose of enabling the Secretary of Health and Human Services to implement these regulations is that they are doing so in the interest of protecting the citizens of our country. And their mandate is a congressional mandate in that it's provided by statute. And so we're trusting
Your argument is because of the purpose, we should presume that Congress wanted CMS to have the authority to expressly preempt state law.
Yes, Your Honor, that would be precisely my argument.
Thank you.
And just to
And
put a
you're-
finer point on that, you are saying that Secretary in this case was acting within the scope of the agency's delegated authority from Congress when saying that our regulations are going to preempt state law.
Yes, Your Honor, because I believe that the Secretary was acting under its statutory powers as given to them by Congress in implementing the IFR, including what they wanted that IFR to contain. I don't believe there are any guardrails within the statutory scheme that gives the Secretary its authority that would prohibit that, certainly. And I think
But also nothing expressed that says the Secretary can preempt. I mean, I keep wanting to find some language that says you can do this, as opposed to look at the purpose and it must have been included in the basket of things that had to be done. You see
Your
what
Honor,
I'm saying?
Your Honor, I'm probably still not going to answer your question, but I'm going to give it a shot. That's the whole nature of the Supremacy Clause, is to allow for laws that are passed by the federal government in the interest of the United States citizens to preempt state laws if they choose to do so. And that's exactly what happened here. And that's our argument.
But typically, we say there has to be some sort of express intent to preempt. And I'm just trying to find the expression from Congress that said the Secretary can overrule state law in doing this thing, as opposed to, well, surely that was included in the authority because this is such an important thing.
It would be our argument that that authority is inherent in the powers that Congress has granted.
And not express.
And
I mean, again, you can't cite me to anything that says, go preempt all these state laws.
I cannot, Your Honor.
Okay.
Well, what about the city of New York versus FCC, which says valid agency regulations constitute federal law for preemption purposes. In such a case, the correct focus is on whether the federal agency that intends or that seeks to displace state law and on the proper bounds of its lawful authority to undertake that action. And then in the wake of that, in 2022, Biden versus Missouri, the issue was, did CMS have the statutory authority to mandate vaccines for healthcare workers at facilities that receive Medicare and Medicaid funding? And the United States Supreme Court in 2022 said yes.
Yes, Justice Standridge, I would completely agree that the Supreme Court has acknowledged that that power exists. I believe that Justice Biles' question was whether or not there's anything in the statute that expressly provides they have the authority. There is not. But certainly the Supreme Court, first in New York, with respect to an FCC regulation, and then more recently, as you cited in Biden versus Missouri, the Supreme Court has recognized that absolutely the federal government has the right to implement regulations, and those regulations then become the law of the land, and the Supremacy Clause applies to those regulations and whatever they say.
For
And-
preemption purposes under New York. Right?
Correct.
And do the regulations themselves have an express preemption?
The regulation does contain an express preemption. Yes, Your Honor. The language of the IFR does contain an
So
express
Your
preemption.
position is that preamble is equivalent to the regulation.
Correct. Yes, Your Honor.
But real quickly, I take it that if we were to disagree with that, you can't point us to language that's not in the preamble that expressly preempts.
To be candid, Your Honor, that is such a lengthy document. I have lost track of what's in the preamble and what's not in the preamble. But I would say this, if the court finds that the language in the preamble is not binding and cannot invoke the protections of the Supremacy Clause in preempting state law, then our secondary argument would be that there's conflict preemption, and we've discussed that already. And of course, we didn't even get to the 14th Amendment due process arguments.
Other questions? Thank
Is,
you.
can I ask one final question on the rational basis conclusion of the district court? I want to hear your defense of that conclusion as to why there was no rational basis for the State Vaccination Act.
Yes, Your Honor. I think the Honorable Judge Hauber in the court below relied a lot on the legislative record and what various legislators were saying when the Vaccine Act was passed. I think it's difficult to argue that legislative record made it clear that at least the people who spoke were making a statement. And their statement was, federal government, how dare you tell us in Kansas what we need to do? But our argument goes a little bit deeper than that. Substantive due process, rational basis, if you will, under State v. Robinson, which is a case from this court, the review of whether or not substantive due process is met is one of reasonableness. And here, Powerback was put in an untenable situation. Either they comply with the IFR and they get fined $50,000 by the state of Kansas, or they comply with the Vaccine Act and potentially run the risk of losing their Medicare funding, which essentially puts them out of business. Now, my esteemed colleague argued there's no way that they would have been found to be in violation of the IFR, but we don't know that because the situation never played out. They were not allowed to provide an accommodation to Ms. Kieran. She was never in the workplace. We don't know what would have happened and whether or not at some point the federal government would have found that they were in violation of the IFR. And certainly it is a plausible outcome. So for that reason, the statute is unreasonable.
Well, that's not the constitutional test for rational basis, is it?
And if we address the rational basis, Your Honor, I'll go back to what I said earlier, which is the Kansas legislature said that they were enacting the Vaccine Act to protect the religious rights of Kansas citizens, but those rights are already protected. So the rational basis was already being met by what's included.
So it's not rational, it's not rationally related to a government, to a legitimate government interest to say we want to protect those rights more.
Well, if in doing so, they completely eviscerate the intent of the right. And here's what I mean by that, Your Honor. All I had to do as a citizen of Kansas to avoid getting the vaccine and complying with the IFR is to provide a piece of paper that said, I have a sincerely held religious belief and don't want to get the vaccine. That's all I had to do. And then there couldn't be any further inquiry and there couldn't be any accommodation that might eliminate the risk I was posing to patients. That's not a rational basis for protecting the religious rights at the expense of everyone else that person's coming in contact with. Did that answer your question, Your Honor?
Yeah, thank you.
Any further questions? Thank you very much.
Thank you. Mr. Carswell?
Going to Justice Biles's point about inquiring into the sincerity of religious beliefs, we agree with Powerback that nothing in Title VII or the EEOC guidance prohibits it, or requires an employer to do that. We also don't think there's anything in the case law that requires that. There's nothing that Powerback cites for sure, and I'm not aware of anything. Powerback referenced the undue hardship test for accommodations. That's not an issue here. Powerback's own policies provided for religious accommodations. They said we allow for N95 masking and testing for people who are granted a religious exemption. They didn't deny Ms. Kieran's request because they said we can't accommodate her. They said we don't think your religious beliefs or assertions of religious beliefs are sincere. So that's not the issue. To Justice Standridge's question about preamble, that not being binding, those cases, we were on page 2 and 3 of our reply brief. It's the 20ville Mining versus Secretary of Labor case.
Wait, can you say it again?
Pages 2 and 3 of
I
our,
heard that.
oh, sure. 20 Mile Mining versus Secretary of Labor from the 10th Circuit. And then AT&T Corporation versus FCC from the DC Circuit. And those both say that the preamble language is not binding. And then here the preamble ends on page 61616 of the Code of Federal Register, excuse me, the Federal Register. And that also, to answer your question about the CFRs, that is where it starts referencing the CFRs. And they're all also laid out on the title page of the Code of, excuse me, the Federal Register. So, was there any further questions?
Does the Kansas Act just permit, I check a box, I have a sincerely held religious belief, and that's enough? I think it does, doesn't it? I mean, just that you can't inquire. So that's enough, regardless of this, regardless of the intent, the interpretation, you can just check the box and that's it.
So I thought about this a lot, and there
Yeah, I have too, because I understand the tension here. I do. But is that what's allowed? I can have any belief at all and say, well, that's religious.
there may be a little room just in that the federal courts make a distinction between sincerity and religiosity. And so, someone may have a sincere belief that's not religious. Now, I think the complication here is the Kansas statute does require the employee to certify that this is their religious belief. So if you're getting into that and saying, no, it's not, then that's, I think, implicating sincerity.
Yeah.
But it may be if they say that, but then it's clear from their statement that it's not religious. If they say, I request an exemption based on a sincere religious belief because I don't like to get poked with a needle.
And why isn't that enough? To invoke the Kansas? Is it?
I think maybe there you could still say, well, you're not, because the statute says you also have to have as evidenced by an accompanying written statement. And if there's nothing in that statement that ties it to religion. Now, if they cross the line and say, because I think being poked by a needle violates my religion, then that would be fine. But and
it could be something, I think it does. I mean, that's enough.
If they say that's their belief, I mean, yeah, don't inquire into that. There may be a minimal amount of ability to push back.
And
But
I think what we're getting, it can also be fraud. I can check this box that says sincerely held religious belief. But the reason I don't want to get this vaccine is because I read something on the internet that told me not to take it.
there is the risk of that.
And so you can game the Kansas system by checking the box and claiming it's a religious belief, and nobody gets to look beyond that under the state law.
There is the risk of that, yes. I mean,
And the employer is required to accept and accommodate even if the system is being gamed because the Kansas legislature said so.
whether it's good policy or not, yes, but the Kansas legislature under rational basis review made the rational determination that, do we be over-inclusive and possibly protect people who might try to game the system? Or do we be under-inclusive and allow employers to inquire into sincerity? And
The answer to my question is yes.
it can happen, yes. And the legislature rationally determined to adopt a law that could allow that to happen, yes.
And one real quick question, just procedurally almost. This is an appeal that for our own analytical processing, regardless of the substantive claims of error that you've raised, they have to satisfy the statutory basis under the Kansas Judicial Review Act for error, right? So we overlay that sort of standard of review on top of the substantive arguments.
Yes, they have to, in addition to, what we're dealing with here is the constitutional violation.
Sure.
So to show that
Right.
the Department of Labor was incorrect in finding they violated the statute.
Thank you.
Was there any further questions? Ask that you reverse the district court. Thank you.
Thank you. Thank you to both counsel for your arguments in this matter. We will take it under advisement